Okay. Hi, everyone. My name's Denise Echeverria, and we're about to start the Governors Committee meeting for Bronx District 12. We will be going over some changes that we believe that should be made for the bylaws of Community Board 12. We have documentations of these changes that we would like for everyone to review. They've been sent to everyone, and we have hard copies amongst the committee members that are sitting here right now. Okay, so we will begin with Article 1. Or every underlined blue text is the revised, and red would be what we want to change. Okay, so we're going to go straight to Section 4, right? That's where the revisions begin, Section 4.
Yep.
Okay, Section 4, an appointed member may be removed. And then you'll see in red underline, crossed out, then you'll see the blue, what we believe should be the revision. From the board for cause by the borough president or by a majority of appointed members of the board, cause shall include, not be limited to substantial non-attendance as defined herein. Okay, A, for purposes of the article, substantial non-attendance shall mean 1, 3 consecutive unexcused absences from general board meetings. 2I, 3 consecutive unexcused absences from any standing committee on which the member serves. Or 3I, more than 50% non-consecutive unexcused absences from the general board meetings or from any standing committee in a period of 8 consecutive months. Any comments to that? Okay, continue.
I think it's a good. I think it's good to have a more firm attendance policy to avoid some of the attendance issues that we've been having, as opposed to the language currently is shall not be limited to 3 unexcused absences. It's very discretionary, and this kind of puts a reasonable yet firm attendance policy forth.
Okay, thank you. So noted. B, the chairperson of the board or the chairperson of the relevant, sorry about that, standing committee with the approve the chairperson of the board may administratively remove the member from the membership of a standing committee upon a finding of substantial non-attendance as defined in subdivision A above. Such removal from committee membership is an administrative action and does not require action by the full board or referral to the governance committee. The affected member shall be notified in writing within 5 days of such removal. Administrative removal from a committee does not affect the member's status as an appointed member of the full board. I'll just take a beat. Hold on, please. Good evening. Okay, we're on Section 4B. Section 4B. All right, now we'll go to C. A member removed from a standing committee for non-attendance may, in the discretion of the chairperson of the board, be refused appointment to another standing committee. Such circumstances may constitute cause for removal from the board as an appointed member. D, members on an approved leave of absence pursuant to Article leave of absence of these bylaws shall not be subject to attendance tracking or non-attendance removal proceedings for the duration of such approval leave. Okay, we're on Section 4. Okay, it's easier, yes. Section 4, we just read A, B, C, and D, revision on the blue. We're done with the D. Now we're going to open to discussion. Flip it over. Flip it over. You have it. All this pertains to you, by the way. So we're going to open the floor to discussion on Section 4, A, B, C, and D. Any comments?
think it would be a better or easier way. So basically, our current bylaws say that you have 3 absences where you have now subject. That's more or less different, right, Robert?
What it said, yeah,
For the original, not
to the original.
It's actually vague. It's not
vague.
even concrete.
Right, it
It's
says
not concrete.
may be removed, but it may include not limited to 3. So there is no policy. Here we're saying there is a policy. It's going to be 3 consecutive unexcused absences, or 3 consecutive unexcused absences from a committee, or more than 50% unexcused absences for a year. So if you fail to go to half of the meetings over the course of a year, whether it be a committee or whether it be a general board meeting, then you should be removed. And if you have 3 in a row that you don't attend, you should be removed.
But it also states, according to B, that it's up to the chairperson of the board, actually, the
Right.
way I'm reading it. So all this can happen, but this is open for interpretation. All this can happen, the 50% non-attendance, the 3 unexcused absences, and the chairperson of the community board can say, hey, this person, I'm gonna give this person another break.
I think the only thing is defining what's excused and what's unexcused. Like, we can do that later.
That's what I'm saying. It is actually, you're right. You're right on that. What defines what's unexcused absence?
Because I think
Right, we
I
don't
think I
have
read
that
it
in
before,
there.
Like the 2020, like I think I read that before about like illness or like certain things, but I think caregiving. But I think that just needs to constitute like in definition, like maybe in the
Right.
maybe there should be like a beginning glossary of like what's excused, what's unexcused, or whatever, just that people understand. And also
Yeah.
that we are holding ourselves accountable for what that looks like.
Also a time frame of when to actually put in for excuse, like not a refusal, but literally you being excused. Like if you have an emergency, right? If I find out at 6:00 p.m., like one time that did happen, I was on my way to a meeting and then of course my husband got his car accident.
Can you send?
Now an emergency, now I cannot be at the meeting. Right, so we put in somewhere saying
Must be
within,
written.
yeah, it must be written, it must be a phone call, it must be 48 hours of the start of a meeting.
Good point. So we'll have an amendment with that. Vice Chair, you have that?
Then that email
Cool.
has to go to the chairperson. Like that email goes to the chairperson.
Right.
Usually, like and district manager, I usually send that to the chairperson, district manager, and Ursula. Just so they know, like if you say in the red.
That's what I
sentence,
did.
Right? That's what.
That's normally I
policy is.
would do.
Yeah.
I would call, not call, but I would shoot a text to Ursula, George, and maybe one other committee member that's on the board. Usually I include them, CC them in, so I'm covered. And
Yeah.
everyone knows, they're on the same page as to exactly why I'm not there.
Okay,
you
yeah,
know.
I think it could be called. I could just whatever form of communication,
Right.
depending on what the person's going through. It could be email, text, call, whatever it is.
But-
you need to contact that person.
I agree 100%. Thank you, Ariel. Thank you for bringing that to our attention. It's so noted. Vice Chair has written this down in his notes. We will make an amendment to that bylaw. Duly noted.
People that just tell
Right.
me at 7:30, 8:00 at night, that they're not still speeding, that it's not.
Okay. So now we're up to section 5. Are there any more comments? Pro or not pro?
This with the removal, it's typically saying that you can come before the board, but now it's been brought down to primarily the chairperson.
Right.
Do you feel that gives the chair a little too much leverage in this instance? Because at least if they're able to come before the executive board, and let's say the governance committee.
Right. So thank you for bringing that up. Maybe we can bring it before the governance committee first, and under the recommendation of the governance committee goes to the chairperson, who then has the power to take this person off.
Just, the reason why I wrote it that way, that was intentional. Number one, if you're going to be removed from the board, that has to be an action of the board, period. Okay, and it probably, it'll go to the governance discipline committee, that'll get all specific. But I think the chair should have some leeway to remove people from committees. Not, because I don't think that's as drastic of a thing as being removed from the full board. So I thought, well, and that also impacts our ability to have quorum at meetings. So I wanted a mechanism for Clinton, if he sees that, I appointed this committee of 8 people and these 4 people don't regularly show up, I want to clean house and get these people off, and I want to put these people on. I want to change the makeup of that committee, as opposed to being stuck with that committee membership for the entirety of the year. If we have a disciplinary proceeding just to remove somebody from a committee, I got to give. You saw when I did it for George. I don't know if you observed. There was a complaint about George, and we did a whole disciplinary procedure. There were 3 meetings over a course of 2 or 3 months. There was, applications and submissions, and we heard testimony. I had to write a decision. It was a very involved process, and I think, to do that on every time someone's, it's pretty cut and dry, guys. The person's either showing up or they're not. So I tried to balance as much as possible. The goal of these amendments was, how are we getting quorum at these meetings? And there's just not going to be a quorum unless there's a hammer that comes down when you don't appear to.
No, I definitely agree with that. That's why I like quantity that y'all settled. You're still sticking to the 3 structure out rule, and then clear cut what will happen next, because that's pretty much what people are looking for. If it's like, okay, if I don't show up, if I'm late 3 times, maybe there might be actual reasoning for that. Is there at least a leeway in that? If I'm just not here at all and I don't give any notice whatsoever, that's completely different. So it leaves y'all making a lot more nuance. To your point with committees, I think that should be sort of like an independent thought, like sort of separation of that the chair still changing the powers, appoint board members as chairs. I think that would.
So can appoint and remove?
Can appoint and board members to committees as he sees fit. Now, when it comes to the removal of a person from the board, that's what I was talking about earlier. Actually, go to the governance
Committee, right. I understood what you were saying.
And then it's left up to the chair to execute what the governance committee has come to a determination. That would be a slight difference, because now it's not just the chair picking and choosing who to say let's go. Now they actually go see the meeting. So you don't have to go through a whole. In my opinion, you don't have to go through to give committee unless that person has a complaint about being removed from the committee, and then that brings off a different scenario. That should also
Duly noted. Thank you. Wonderful. Okay, so now, anything else? Can we move on? If any other, go ahead, Clint. We don't have anything about lateness. Okay.
If you have something you want to add, let me know.
Okay. So now, if we're done with section 4, we'll move on to section 5, everyone. So, section 5, removal of an appointed member from the board, whether initiated by the board itself or recommended to the borough president, shall be subject to the following procedure. Okay, let's go. All right, A, initiation. Any board member may file a written complaint with the governance, bylaws, and discipline committee, setting forth the basis for proposed removal, including the specific cause alleged. B, governance committee review. Upon receipt of a written complaint, The governance committee shall investigate the matter and shall provide the affected member with written notice of the complaint and its specific allegations within 10 days of receipt. The affected member shall have the right to appear before the governance committee to submit a written response and to present evidence on his or her behalf prior to the issuance of the committee's report. C, report to the board. The governance committee shall present a written report of its findings and recommendations to the full board at a regular or special meeting, the agenda of which shall include action on proposed removal. A copy of the committee's report shall be provided to the affected member not less than 5 days prior to such meeting. D, board vote. The board shall receive the report of the governance committee and the response of any of the affected member. A motion to remove the member shall require approval by a majority of the appointed members present and voting. No such vote may be taken unless a quorum is present. Taking comments from the floor. Section 5.
I wrote this because we don't really have a procedure for the governance committee to evaluate complaints. We did the best we could last year with the complaints that we received, and this is generally the process that we followed last year. If you can see the language that's stricken out, talks about the borough president shall not remove a board member. The borough president can do whatever she wants. I mean, pursuant to her authority, it's not really for our bylaws to say. So this is just kind of mapping out a procedure that we've already followed and I think worked pretty well last time.
Any other comments? We're moving forward. Of course, any can send anything to us after this.
John?
Yes, John?
Yeah, so we like include the council member because they appoint the borough president appoint. So we just change that to public official.
What did he say?
We didn't hear that.
Oh, you didn't hear it. I'm sorry. I said the borough president appoints some of the people, but the council member also appoints some of the people also.
Yeah, we got Eric Dinowitz and Kevin Riley.
Yeah, so should we just put elected official or responsible elected official?
Right.
Which provision? Where are we?
Well, the authority still lies with the borough president, so she's the one that actually appoints. John's saying that the council members are the ones that give the reference for people to be on a community board. That's why
Right.
we interview with them first. But it's ultimately.
I believe Kevin has 7, Eric
President's
Dinowitz has 2.
to actually appoint someone to the community board. So what we're saying is that we want to still retain that power, because that's something we can't do anyway. That's a object. She literally has that authority to put whoever she wants, to remove whoever she wants. What, John, are you trying to say that they should be included in the conversation if we ever get to a point that someone that they suggested to be on the board should be removed? So let's say Councilman Dinowitz put me on the board and I'm up for removal according to the board. Should he also be contacted? Is that what you're saying? If that was to ever come to pass?
Yes, and also he could remove you if he have to.
The way not the charter, which thing is about it? There are too many avenues. But basically it boils down to the borough president retains the authority in that. It's not up to the city council member that gave you the reference. It's literally up to her by law.
The city charter, that's correct.
Yeah, that's right.
Section 2800 of the city charter.
Would it be fair to ask for the person that brought you in to be there as a character witness if necessary?
Or we could just say, I mean, we could say that the city councilman gets notified of any removal proceedings.
Right.
Yeah,
We could just say both city, just to make it easy, just say both city councilmen get notified of any removal proceedings.
Nice.
Yeah.
That's all.
John, is that addressing your concern?
Yes, it is. I just was saying that they should somehow be included because they appoint you, you know.
So someone from the city, both, just as opposed to us, undertaking who appointed who, because
Just contact.
honestly, I don't know. I have no idea. But just notify both council. There's only two.
Yeah.
Yeah.
I mean, the borough president's office has to say.
You know, what I'm saying is that I think Kevin Raleigh is responsible for a certain amount of members on the board.
Kevin Riley
So-
is responsible for 7, Eric Denowitz 2.
Right.
Okay, so the quick question is, now suppose we want to remove one of Kevin Raleigh's guys, right? Does a borough president take precedent over removing that person?
Yes.
Okay,
Under the charter, yes.
okay.
Yes. Any other comments on section 5?
So just to make it even on the safer side, if someone's up for removal, the borough president's office is contacted immediately, as well as the city council members for our district. We didn't say that. We literally said that like a couple of times now. We understand that. It's just that we want them to be a part of the conversation if there was ever to get to that part.
That makes sense. You're on board, Clinton? You sure? All right. I think what was being proposed is an additional line in this section that says upon any disciplinary proceedings, there'll be notification to the borough president's office and to both city council. Notification. We're not talking about anybody's rights.
Okay, so moving forward, Article 3, Section 6. The board shall not remove a member except in accordance with the procedures set forth in Section 5 of this article. Nothing in this article shall limit the authority of the borough president to remove an appointed member pursuant to Section 2800 of the charter. Section 6, Article 3. Article 3, Section 6. We're still continuing. You had it, turn it. It's 5, it should have 6. Right, he has it. Yeah. No, we're right here. Right, yeah. All right, any comments on Section 6, Article 3? If not, we'll move on.
I mean, you just take out the second one. You keep it at just the board shall not remove a member except in accordance with the procedures set forth in Section 5 of this article. Because as we just talked about ad nauseum, we all acknowledge the fact that the borough president is ultimately the one that has the last say. So,
But I think we need to keep that in there, because we understand that, but for like others,
May I just reiterate?
it needs them to like have to read where it's like, okay, this is standing, let's
stop it. Right? Sorry. We also just put in the process itself. It could be very short of that. The principal will go before the governance committee first, then the chair.
But that's Section 5. That's what
It's
Section 5 says.
Already on to that, we're on Section 6.
No, I know.
Six.
I'm just saying, like, there's usually sometimes there's also like an image, literally, of just governance person as an arrow, such and such.
Well, I mean, it says A, B, C, D.
I know.
I mean, we could do
a carrot.
Yeah. Thank you.
All right, let me look at that.
Because it would literally just help so that people actually understand it going forward along with the sentence.
Any more comments from the floor for Section 6, Article 3? Okay, moving forward. Article 4, hearings and meetings. All right, we'll go to Section 7. I'll give you guys a minute, Section 7. Article 4, hearings and meetings.
That's good.
Okay, section 7, whenever the board considers an item referred under the Uniform Land Use Procedure, the constitution of a quorum shall be determined in accordance with provisions of section 4.043 and 4.061 of such procedure. For all other matters, the presence of 1/3 of the appointed members of the board shall constitute a quorum. No member may be present by proxy. In blue, we have no member of the board may vote, be counted toward quorum, or otherwise participate in any meeting, hearing, or proceeding of the board or any committee thereof by proxy or through any representative or designee acting on the member's behalf. All participation must be by the member in person or where authorized pursuant to these bylaws and applicable law by the member appearing remotely via video conference as provided within. Okay, so any comments on this?
I mean,
Taking comments from,
just the intention here, I read through the bylaws, I didn't see anything that really said there's no proxies, with the exception of this where it said no member may be present by proxy. So that's really the purpose of this, just to say that you can't participate even online with a proxy.
Right. The only thing that would be is just literally putting in the e-alert as well as the e-alert, because that's in the process.
What do you mean? What do you want to say, Euler?
That's
right,
what
we're
we,
talking about.
no, I'm saying you also have the e-alert as well.
Okay,
Right, so you gotta put e-alert as well as u-alert, so then there's no like, oh, what if it's a u-alert thing as opposed to a u-alert thing?
Well, the Euler portion of this is what's there currently.
Mm-hmm.
I didn't add that. I only put
Yeah.
the stuff that's underlined. Okay.
That's what I'm saying, just add
I'll
in.
add Euler.
Yep.
Euler, sorry.
Oh, because this is solid. It literally is, it's throwing it back to the beginning in terms of the book as provided therein. So it's like, it's already giving you the notice that you have to look back to the beginning to see what the rules are for it to be counted towards quorum.
okay. Any other comments from the floor? So section 7,
Well, president meaning that you have to be on video conference.
can we please include everyone in on the conversation? Excuse me.
Got it.
I was just asking to clear
No.
out the sentence.
Any other comments on section 7? Okay, moving on. Section 11, no, section 12. Remote participation, generally, the board may permit members to participate in board and committee members by video conference in accordance with New York State Open Meetings Law 103-A and all applicable state law and guidance. The board shall adopt and post on its website written procedures governing remote participation prior to permitting any such participation. All remote participation shall comply with those written procedures. Any comments? Section 12.
Just briefly, I mean, there's a series, the next 1, 2, 3, 4, they all kind of go together. The next 3 paragraphs, next few sections all kind of go into remote participation issues. But there is no remote participation policy really in the bylaws. There was a resolution passed last year that I think Tulane shared with some of the members, including myself.
Can you say that again?
I said there was a remote participation policy that was approved that Tulane shared with me and some other members. But I looked at it, and in my view, that resolution did not successfully set forth the parameters for remote participation, and the bylaws were never formally updated, at least the version that is being shared online.
The one that you're referring to is 103C, where it says, all right, so I'm not talking about what they're referencing. So
Okay.
they usually go by-
Are we moving forward? Let's stay on 12, and then I'll just read the other ones in accordance with 12.
Following up with the outline. So.
Okay.
All right, hold on.
Literally is stating Members of the public shall be physically present at any such meeting unless such member is unable to be physically present at any such meeting location due to extraordinary circumstances as set forth in the resolution and written procedures adopted pursuant to paragraphs A and B of the subdivision, including disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. Notwithstanding the in-person quorum requirements set forth in this subdivision, the public body may determine through its written procedures governing member and public attendance established pursuant to and consistent with the section to allow for any member who has a disability as defined in section 292 of the executive law, whereas such disability renders such a member unable to participate in person at any such meeting location where the public can attend, to be considered present for purposes of fulfilling the quorum requirements for such a public body at any meetings conducted through video conferencing pursuant to this section. So, for example, Carl would be online, right? Carl falls right in line with this. If Carl's not physically here, he could be counted towards quorum because he literally falls into the parameters of this. Same thing if someone has a caregiving issue and they are actually a part of the committee. As long as they are online when you take the vote, you are good, and they can also be counted towards quorum. So that's the resolution that Talim was pointing out to. Now, we haven't been following fully through with this because for whatever reasons. There are plenty of reasons why we weren't following exactly through with this. So my suggestion is, it's already here in print. We already have it. Just make it literally inside of the documents. Exactly. I agree.
Go ahead.
Also, when there was a question, I contacted Benjamin Solitaire, CEC, to get the correct information, which I also made sure everybody has, which is here. It's been sent out. I don't know how many times. It's excessive of what he said, what was pointed out, and it was exactly what you said, and it's right there. He even got to the point where we called a few times. It was Carla, Beatrice, and myself on conference call with him, that he sent it to us and bolded the part that we keep asking him about.
So we got this information.
Yes, ma'am.
So if I may speak, please. Okay, I agree 100%. Eutonia, what you just read is very clear cut and precise, actually. And it does address the fact that excused absences due to medical and caretaker. I feel that this should be inclusive into our bylaws so there are no mistakes in the future. This is something that we have been tackling back and forth about making quorum if you're online, excuse absences, medical reasons, caregiver reasons. That right there from Benjamin Solitaire, that ruling that you have should be inclusive in our bylaws because we've been tackling this situation, and because it's not in our bylaws, we've had problems. So to avoid any future problems, this needs to be included into our bylaws. Chair recognizes Vice Chair.
That's fine with me. This version does not say, just to be clear, it does not say that the persons appearing telephonically count towards quorum. The current bylaws, as they're posted online, do not say that the people appearing online are counted towards quorum. The de facto law, like if we're just going to go to what it is, New York State law, it says, as far as a baseline, you do not count towards quorum, but you may develop procedures, just as Tulane said. Now, we tried, it sounds like, to pass procedures. This was 2024, or no. Yeah, November 21st, 2024. We tried to pass procedures to allow video conferencing, but it says that the language that was written says the public body may determine through its written procedures to allow a disability and count towards quorum. That the actual the actual language that the quorum is authorized and those individuals who are meet the disability requirements can count towards the quorum, that language never was approved based on this resolution that I was handed.
Okay. Can I,
This one.
give me a minute, please. So like I'm saying, like I was trying to say before, and I'm going to make it very clear cut at the moment, please, that we adapt this policy, that we avoid any further situations where there's a disagreement or it's not clear to everyone. If you're on video and have an excused absence, medical or caregiver, that you do count towards quorum so we can avoid these back and forth issues. I would like to move on, please. We have a lot more here that we need to go through. I'll take one more from the floor if anyone has anything to say online. Does anyone have a comment to say about this? Okay, then we are going to move on, please. Okay, section 13. Extraordinary circumstances, a member may participate remotely by video conference where the member is unable to attend in person due to extraordinary circumstance, which shall include but not be limited to A, disability or illness, B, caregiving responsibilities for a child, parent, or other dependent family member, C, any other compelling circumstance recognized under applicable state law or guidance. A member seeking to participate remotely shall notify the chairperson or district manager as early as practicable prior to the meeting, stating the basis for remote participation. That's clear cut. Section 14, quorum and voting for remote participants. A member participating remotely by video conference pursuant to the article may fully participate in deliberations and shall be entitled to vote on any matter before the board or committee. However, a member participating remotely shall not be counted toward the quorum requirement unless such member qualifies a person with disability with the meaning of executive. Okay, so we just went over this.
Right. So we're going to change that to shall be
Right.
counted.
Shall be counted. Okay, so moving on, section 15. Camera requirements. All members and members of the public participating or speaking remotely and any board or committee member shall have their video camera activated and their face visible to the board for the duration of the participation or testimony. A committee member, okay, I see. A member who is unable to activate his or her camera due to a technical failure shall promptly notify the chairperson who may, in his or her discretion, permit continued participation while the technical issue is being resolved. Members of the public who join remotely solely to observe and who do not speak are not required to activate their cameras. I honestly, I don't like that part. I think if anyone is gonna come and see us remotely, should respect us the same way we respect them and show their face. I don't know how anyone else feels. Is that, Clinton, is that a policy that's been adapted or can be changed?
They're members of the public. They should have their camera on, but do they have to? Because they're just watching. They're just listening.
Okay.
I can strike it and leave it ambiguous.
It's members of the public versus board members.
Yeah, I just thought, I don't want to be seen as excluding members of the public. That's the reason why I put that there, but I could strike it.
I also have another thing about that. There are some people who don't have phones that can show like video. Like Carl doesn't have a phone that can show video. So I think that sometimes we need to be a little bit mindful. I feel like it's different about capability and not capability kind of thing.
If you read it, it's in there.
Yeah.
They should notify the chairperson.
Yeah,
as to-
just to notify
Right.
like if that happens. But I'm talking about the members of the public, like if they don't really have that
Okay.
capability.
Okay, it's just a little peeve of mine. I get it.
No, I get it. You see me, I can see you. Like,
Right,
like,
exactly.
like,
I'm showing you mine, you show me yours. Not the way it sounds.
Comes to present
That's what
should
it's.
have to be on it, but when it comes to members of the public, maybe they're also not camera ready. Some people are running back and forth in their homes. So it's like, give them like.
Okay. All right. Before I stand corrected, thank you.
Because what if they come forward, they have like a personal thing, but for their own safety, they don't want to show where they are.
Okay.
There's also a safety concern.
No, I
Thank you,
I
Dee.
was saying that there are, I don't want to say senior citizens, we'll say teenagers who are not familiar or technically savvy. And so they are also part of not knowing how to do this. Yeah, John had his hand up. I don't know what happened.
John?
Yes, you can hear me?
Yes.
Okay, so remember when we first started to go remove that there was like some kind of ordinance that came down from the governor or from the state. So does it supersede what the state said with opens meetings law?
I understand it. I understand. I know exactly what you're saying, John. All right. So, John, there is a law that says very specifically that it's in the construction law about quorums. And that section says people appearing telephonically or video conference do not count towards quorums. However, there's another section of the law, okay, that says very specifically that a public body can pass into its own bylaws a procedure for individuals who have a disability for those emergency circumstances where they cannot appear, either for child care or for a health and safety reason. As long as we have written procedures built into the bylaws, that exempts us from the general rule, which is that the telephonic individuals do not count towards the quorum. We will now be able to count them towards the quorum. And that is what Tulane has been saying. It was stated from Benjamin Solitaire from was it Civic Engagement in New York City.
Okay.
So excused absences on video right now online can count as quorum for our meetings.
Okay.
Count towards quorum, rather. Thank you, John. All right, so we'll go now to section 16, if there's no more comments on section 15. Section 16, accessibility. The board shall make cause to be made or reasonable, should make or cause, all right, I'm sorry, I don't have my reading glasses, everyone be patient with me. To be made or reasonable efforts to ensure that its meeting and public hearings are held in facilities that permit barrier-free physical access to persons with disabilities, as defined in subdivision 5 of section 50 of the New York State Public Buildings Law. The board shall further make reasonable efforts to ensure that materials distributed at or in connection with board and committee members are accessible to the members and members of the public with visual impairments or other disabilities. The chairperson shall designate the district manager or another staff member as responsible for coordinating accessibility compliance. I don't see anything wrong with that one. Does anyone, I agree, does everyone agree with what we just read on section 16? All right, so let's move on. We're going to be going to Article 5, offices. All right. 5 offices. We're going straight to section 5 of Article 5, offices. Give you guys a minute to get there. Article 5, offices, section 5. All right, I'll begin reading, section 5. An officer may be removed from office for cause by a majority of the appointed members of the board. The procedure for officer removal shall be the same as that set forth in Article 3, Section 5 and 6 of these bylaws governing the removal of appointed members, provided that A, only board members may initiate removal proceedings against an officer by written complaint to the governor's bylaws of discipline. Okay, I saw that as well. Committee, B, the officer whose removal is proposed shall have the right to appear before the governor's committee to submit a written response and to present evidence on his or her behalf prior to the issuance of the committee's report. The highest ranking officer who is not subject of removal proceedings shall serve as acting chairperson of any board meeting at which action on the removal is taken. That's pretty clear cut. Does anyone have a comment on that? Okay, moving forward. Okay, Article 6, committees. Article 6, committees, Section 1. Section 1, Article 6, committees. Okay, Section 1, the following shall be established as the standing committees of Community Board 12, the Bronx. Executive Committee, Governors Committee, Bylaws and Discipline, Housing, Transportation, and Land Use Committee, Public Health and Education Committee, Public Safety, Parks and Recreation, Environmental Concerns Committee. Pretty clear cut. Is everyone on that same page? So we can move forward.
Yeah, the only thing I would say is if we have the names of those committees, it'd be nice to get that all done and wrapped up.
So we're still working, a work in progress, so perhaps by next month, I'll do, yeah, okay, so we're good for now, all right? Right, we're good for now. When it's completed, it's completed. Okay. Okay, Section 6, Executive Committee. All right, so I'm gonna go straight to B. Section 6B, Executive Committee, Emergency Authority. I'm gonna give you guys a minute. We're still on Article 6, Committee. Okay, Section 6 on B. B, Executive Committee, Emergency Authority. In emergency situations where a failure to act before the next regularly scheduled board meeting would result in irreparable harm to the board or the community district, or where a legal, regulatory, or land use deadline would be missed. The executive committee is authorized to act on behalf of the full board, provided that the chairperson determines in writing that an emergency exists and that the matter cannot reasonably await the next regular board meeting. I-1, notice of the proposed executive committee action is provided to all board members as soon as practicable, and all members are afforded the opportunity to attend and observe the executive committee meeting. I-3, any action taken under this provision shall be placed on the agenda of the next regular board meeting for ratification by a majority of the appointed members present and voting. If such action is not ratified, there should be no further implementation of the action after such meeting, and the board should take all reasonable steps to withdraw or rescind the action. For purposes of the provision, an emergency includes but is not limited to an expiring ULURP deadline, a court-ordered response deadline, a city agency submission deadline, or any other situation in which the board's failure to act would permanently foreclosure a right or opportunity of the community district. I'll take comments from the floor.
Only thing added, e-learning. That's it.
What was that?
Because, again, the only thing added, e-learning.
E-learning.
This is it.
Right, yeah, I think the idea was just to have a procedure. If there's an emergency, the executive committee can come on board and do something. E-learn.
Yeah.
Add e-learn.
Okay, moving on. Okay, we're on E, same committees, Section 6. We're on E now, subcommittee and study groups. Chairperson of the board may establish a subcommittee or study group for the purpose of examining an issue germane to the jurisdiction of any standing committee. Membership in a subcommittee or study group shall be limited to appointed members of the board. Members shall be appointed by the chairperson of the board. A subcommittee or such group shall have no independent authority to take action on behalf of the board or any standing committee. Its function is advisory and investigative. Findings and recommendations shall be reported to the standing committee to whose jurisdiction the subject matter is germane. A subcommittee or study group shall be deemed dissolved upon delivery of its report or upon determination by the chairperson of the board that it has served its purpose, whichever first occurs. A subcommittee or study group without a specified term of existence shall be then dissolved immediately. Following the annual officer elections next succeeding in creation, unless affirmatively continued by resolution of the board or public declaration of the newly elected chairperson recorded in the board's minutes. Comments from the floor? I'll give you guys a minute. A little wordy.
Well,
Maybe
I mean,
like-
the point here was just to make sure it's clear that the chairperson, if he wants or she wants an issue to be studied, he has the right to form a study group or
Right.
committee that'll report back up to the board that it's under. So for example, in the, let's say, committee one was looking at an issue of handicap accessibility on buses. And this was a major issue that we were concerned about. In that, Clinton might find 4 members who he says, you know what, I want them to study this issue and report to committee 1 and make a presentation. That's all this says.
I got it. It's just, I think it could be more concise. Okay?
I'll try.
Thank you. Yeah, together. Yeah. Seems a bit repetitious and wordy. All right, moving forward, E. We're still on the same section. We're on E. Subcommittee and study groups. Oh, we just did that. My apologies. Everyone. Now we're on section 8. Oh, Clinton is on point. Section 8, committee quorum. A quorum is required for any standing or special committee of the board to conduct business, take action, or pass resolutions to be forwarded to the full board. The quorum requirement for all committees of the board shall be governed by Section 41, the New York General Construction Law, which provides that a quorum consists of a majority of the total membership of the committee. For purposes of this section, total membership means the total number of members appointed to the committee, without regard to vacancies or members who are disqualified from acting on a particular matter. No committee may conduct business, vote, or transmit a resolution or recommendation to the full board unless a quorum is present. The provision applies to all standing committees, special committees, and executive committee of the board. Comments from the floor?
The addition of 103 as stated in the open meeting law. So where it says, according to section 41, it should also be a comma, also according to open meetings law, provision 103.
Got it?
Yeah, and I want to get rid of may conduct business because if we want to meet and talk, I think that's okay. I know
Right.
that's a little bit controversial, but
Right. Like for instance, if you have a committee meeting, you don't make quorum, still discuss the matters at hand, especially if you have guest speakers. Move forward with the meeting. But the way this is worded, it's saying, no, that's it, no business conducted. That's it, so it's finished, meeting dispersed. In other words.
yeah, that's basically what it's supposed to be. All right. Hopefully, we're not going to be finding ourselves in this situation all the time anymore. Once we. That's why. That.
Okay, so let's table that one, and to Clinton, you can get us something that is written.
All right, we'll talk about it. Well, yeah. If you want to, only if you want to. anyone needs a quorum.
Right.
Right, that's not a committee.
No, you
He
don't
has
need
a
a
point.
quorum.
You don't need quorum for a study group. That's just,
This is a study group.
I was gonna say a certain word I shouldn't be saying, but no, I will not. I will keep it professional. Thank you.
They're just investigating
Right.
an issue. Okay.
Good
Noted.
catch, Clinton. Thank you.
Might be easier-
Anyone else, please?
It just might be easier if you have to redefine business. Literally just the actual business of, because every single time we even have a standing committee meeting, we're not necessarily voting on stuff. Sometimes it is only presentations or hearing from the public. So if we say, oh, we have to only be able to vote on this, that's not how the actual committee operates. It literally is on the basis of what is actually necessary from the community itself. So if you're in land use, for example, you're not gonna always have something coming up to you from land use, not all the time. It's more frequent than, let's say, environmental, who has a concern, but it's not necessarily something that's time sensitive that you have to vote on. So it's like if you make this a little more broad of getting to like an actual part of what the committee's supposed to do, which is actually hearing from the public, I think that'll make your definition of business more broad.
The problem is the phrase conduct business is directly out of the statute. That's why we're using that phrase conduct business, because that's what the quorum provision in the construction law says. It says conduct business. It's not my, choice to use that language. I don't want to use that language.
Because it's vague.
Because it's vague, I agree. It's vague, and I think it raises a reasonable question about whether or not you can even have meetings. I've always taken that if we do something incorrectly, right? Like, let's say we have a meeting and we vote on something and we don't have a quorum, that action can be considered illegal. But if there's no action, there's nothing to be considered illegal. Then we're just in a room and talking. And that's the point that I've tried to make on this issue, is that I don't think it's a problem because there's no action in which to declare ultra vires. There's nothing that we can say exceeded our authority under the law.
Thank you. So noted, Tonya. All right, so now Article 7. Okay, can Kamar Mullins please identify yourself? Can you please unmute yourself?
Yes, hello, good evening. Hello,
Yes?
yes, good evening. I'm currently new to the meeting and stuff like this. I'm a new business owner on White Plains Road, and I came to see George a while back, pertaining to my business, and it's my first time in a meeting, so basically I'm observing and try to see what everything is all about.
All right, thank you, sir, and welcome.
Thank you.
Okay, moving forward, Article 7, public hearing. We're gonna go to B. All right, Article 7, public hearing, B. Executive Committee Emergency Authority. In emergency situations where failure to act before the next regularly scheduled board meeting will result in irreparable harm. Didn't we just read this? No. Okay, it's repetition. Result in irreparable harm to the board or the community district, or whereas a legal, regulatory, or land use deadline would be missed. The executive committee is authorized to act on behalf of the full board, provided that I, the chairperson determines in writing that emergency exists. Didn't we just do this
I think
one?
we did.
We just did that with my apologies. And we did subcommittees and
Yep.
study groups. All right, so we're moving along. So, Article 9, the amendments, Section 2. Article 9, Amendment, Section 2. Notwithstanding the notice requirements of Section 1 of this article, an amendment to these bylaws that was not included on the agenda distributed prior to a general board meeting may nevertheless be considered and adopted at such meeting, provided that A, A motion to add the proposed amendment to the agenda is made and approved by vote of not less. Please turn off. Can you please mute yourself? Thank you. Board meeting may nonetheless be considered and adopted at such meeting, provided that a motion to add the proposed amendment to the agenda is made and approved by a vote of not less than 60% of the appointed members present and voting at such meeting, and B, following such addition to the agenda. The proposed amendment is adopted by a vote of no less than 60% of the appointed members present and voting at such meeting. The foregoing procedure shall be reserved for genuine circumstances requiring prompt action and should not be used as a routine substitute for the notice and vote procedure established in Section 1 of this order. I'll take comments from the floor for this one.
Can I just briefly explain what I was going for here? There's been a couple of instances, and specifically last month was an example, where we wanted to amend the bylaws to create the discipline committee, and we couldn't do that because it wasn't on the agenda, okay? And George correctly noted that it's got to appear on the agenda first. So what I'm saying here is, okay, let's kind of understand why that rule is a rule, because we don't want the bylaws willy-nilly being changed without proper notice to everybody. But if there is an emergency situation or a circumstance where we really feel it necessary to amend the bylaws and we have a super majority of people who both think it should be added to the agenda and it should be approved, then there should be this kind of emergency mechanism. So that was the thought process. Yeah.
New business?
Yeah.
So
It's new business. New business has erupted during a meeting. There's no specific, that's why it's called just new business.
I can answer that. We have new business and we can add items to the agenda and consider them as new business. However, the bylaws currently provide that we cannot take up a matter to amend the bylaws unless it's memorialized in the agenda meeting. That is the current standing. So that's why I'm trying to make it clear that we can, as long as we have a super majority, right? So we're paying reference to the fact, okay, I understand why you don't want to willy-nilly amend the bylaws, but if we need to for an emergency reason, because we want to get this governance committee off the ground before the end of the year, maybe we should be able to do that with a super majority vote. That was the idea.
As well as like even quick edits, because now that we've actually named some of our committees, right? Technically, the bylaws are like kind of antiquated because they don't reflect what the real standing committees are. So it's like, I agree with you wholeheartedly with this, because again, it's not leaving leeway to just changing the bylaws one way on Tuesday and changing the bylaws to something on Thursday. To a greater point though, independent of the bylaws in this, when it comes to new business that's conducted in our meetings, we're often told we can't do that because it wasn't stated in the agenda, and that's not what our actual bylaws say.
Well,
and that's Ms. T's point about new business in general, not according to the bylaws.
Right,
the way our original bylaws read is that we have to have it on the agenda, and I agree that we should. But I like what Bobby's suggestion is that it also includes that, but in cases of emergency, like right now, when we need to have our committees be changed, if we don't put it on the agenda for a name, but a name arises during new business or something like that, that should also be accounted for in the meeting. Right now, the way that this reads, people are, again, conflating two things. They're conflating changing the bylaws as well as just with new business in general, and then people don't understand entirely what new business can be and what should be on the agenda beforehand and what shouldn't, which is basically just up to new business.
I think we have to verify what is considered new business. Like, because the thing about it is, like, when you are going over guidelines, stipulations and everything, somebody on the outside in has to be able to read it and understand that. So certain words, certain terminology that we know because we've been here needs to kind of be put there, definition, glossary, whatever, like, what is considered new business. That way, when we're conducting, it is new business and we're all clear, like, what it falls under. I think that would probably help with
Yeah,
that.
no, exactly that. And John has his hand raised.
Duly noted. Thank you, Etonia.
Thanks,
John?
guys. Just a quick question. I think the open meeting law, because I work for DDC. Whenever we have or we're making a presentation, you have to actually have it on a public calendar for 10 days, right? So I just want to make sure that, I remember George and Ursula having followed the open meeting law. So I don't think we should change the bylaws. I think we should still stick with the open meeting law. And if new business occurred, then it's new business, like you guys are stating. But I still think we should stick by the open meeting law so that we within the legal limits of the city. I mean, Robert, you could add on to this, but I don't know if you understand where I'm getting at.
I don't want to violate the open meeting law either. So, I mean, if you're aware of a provision that's in violation of the open meetings law by us,
Yeah, there's a certain amount of days that you must have a notice, a public notice of
Let me-
this meeting.
I'll take another look. I'll take another look.
Yeah.
Yeah, we'll table it for now.
Okay, duly noted, John. Thank you. We're going to table it for now. Thank you. All right, so if there's no other comments from the floor, still open? Okay, moving along. Article 12, conflict of interest. Oh, wait, sorry, I skipped ahead, guys, to you blurb. Article 11, code of conduct, conduct. Violations of the code of conduct after proper warning may be subject to removal from a meeting and/or review by governance, bylaws, and discipline committee. I think that's clear cut. We can move along, right?
I'm sorry, it's saying by governance, bylaw, and discipline. I'm sorry.
Governance,
Which is bylaws.
governance committee. And in parentheses, it says bylaws and discipline.
So governance is bylaws and discipline.
Right.
Oh, see, it's fun. That's what we're doing. We just didn't put nominating committee into it because that's literally just something independent of it. That could be something we think about for next year.
Oh yeah, we could table that. You could explain that to me later.
Okay.
Okay. No, it's okay. Yeah, she's good for now. Article 12, conflict of interest. Section 1, no appointed member of the board shall vote on any matter before the board or any committee of the board which may result in a personal and direct economic gain to the member or to any person or organization with whom the member is associated. That's clear cut. Yeah. Section 2, no appointed member who's an employee of the city of New York shall vote on any matter before the board or any committee that has been or may be considered by the member's agency. That makes sense. Section 3, that's no appointed member who serves on the board of directors or in a leadership capacity but not-for-profit organization shall vote on any board matter recommending funding by city agencies for such organization. Section 4, a member who has a conflict of interest with respect to any matter before the board or committee shall, prior to any discussion of such matter, publicly disclose the nature of such conflict. Following such disclosure, the members shall declare present but not entitled to vote. When a matter is called to a vote and shall refrain from voting. A member who is not entitled to vote due to a conflict of interest may nonetheless participate in the discussion of the matter. Section 5, where a member is not entitled to vote because of a conflict of interest. Okay, I want to go to the one before that because there was a situation that we had. The person was commenting and it was a conflict of interest, but no one knew there was a conflict of interest from the get-go. I think that person should be identified prior to making comments.
Yeah, you're supposed to.
Right. That wasn't the case at our last meeting.
When you
Right.
could I just say something?
Go ahead, John.
John, yeah,
I
we're waiting.
actually think that this number one is redundant because if you are with a government agency, like again, I said, I'm with DDC, you have to actually fill out a disclosure form and actually meet with the lawyers. Because when I started my job, they made me go through like the third degree about recusing yourself, um, answering questions about DDC and all that stuff. And the same thing, that that this whole thing is covered by the city under their charter already, I think. So
We need that.
I don't know. There's something again we should just check out because we might be duplicating something that's already being covered already.
No, I think if we're discussing on voting on a situation and there's a conflict of interest and the person sits on our board, prior to commenting, we should know that person has a conflict of interest in this.
Like,
Yeah, but that's what I'm
That
saying.
was
You're
not the
supposed
case
to.
at our last
No,
meeting.
you're supposed
The
to.
person
You're
was
supposed to
com-
disclose.
Excuse me, John, I'm speaking. I have the floor, please. And then you can go. The person did not comment at all. The person continuously commented throughout the whole situation. And it was about the projects, and the person never disclosed that the company she worked for was the one that was remodeling these kitchens. And throughout the whole session, she commented in favor of said agency without disclosing that she was a conflict of interest.
Denise, Anthony has
No, I'm sorry, John, my apologies, John. You have the floor.
I totally understand, but that's her fault. She should have actually disclosed that from time the meeting started, and say that she worked for this company, whatever. But that's what you're supposed to do. That's what you're taught to do. But it could be that she's never been in that position before.
yeah, I'm with you.
So the reason why I put this in is most community boards have a conflicts of interest section in their bylaws, and we did not. So it's incumbent right now for us to be, like John said, take the cues and the information from our agencies or the materials that were received from the borough president's office. But putting it in the bylaws, I think, protects the board from a lawsuit where it said we didn't properly notify a member or take action against a member because they didn't disclose a conflict. We don't want something to be overturned or challenged in court, and it said, well, they don't even have a conflict of interest proposal. So this is a conflict of interest sequence of provisions that other community boards use in the city of New York.
Yep.
And that's why it was added.
Okay, but I would just like it to be amended that person must disclose prior to commenting that there's a conflict of interest and why.
Duly noted.
No, they did not. So maybe we need to put it in our bylaws. Okay, but now it's in
But I
our
think if
bylaws.
we announce it, like if we announce it, because a lot of this is also like teaching new members and everybody, because the only person who did that a lot that I remember was Luke.
Yeah.
Luke always said that in
Right.
the beginning, and I didn't read anything. I just saw I'm like, okay, like that makes sense. I don't think she kind of knew about that.
Okay,
'Cause she
maybe she
mentioned
didn't,
it
but
after,
now we have
need
it in our
to- No, I
bylaws.
agree with you.
Right.
The only thing is, I was going to say that I think maybe we should add, because we're talking about governmental bodies, nonprofits and everything. We should probably also add I don't know the proper language, but like businesses, firms, anything beyond governmental, because not all of us work for the government per se.
Okay, so
but
we
you
can change the verbiage.
the verbiage of
Right.
just making sure it extends into other.
Duly
situa-
noted.
Yeah.
Thank you. I see you.
That's good.
I see you.
Because we left ourselves out.
All right.
That's a good point, Ariel.
Okay.
Everything's kind of saying.
Governmental.
Right.
Yeah. Mhm. and somebody may know somebody in the construction or something that's gonna
Technically-
private sectors.
City, but work for subcontract.
Subcontracting, but
Right.
also private sectors. That's what I'm
The
thinking.
private sector,
stuff like
yes,
that.
there you go. Okay, so let's move forward. Any more comments on this? Okay, we're moving forward. Yes, we're here. Okay, we're on section 7, I believe. Or make a public.
Hello, my hand is up. My hand is up.
Oh, okay. Go ahead, Anthony. My
Yeah,
apologies.
I just needed to understand, like, what will be the protocol if that person does it again? If it does, because it looked like she was soliciting the company, you know, and at the end we found out that she had affiliation with the company. Like, what do we deal with? How do we deal with these people that come in here and they do it more than one time? Like, can we put something in the rules about that?
Yeah, that, well, because we're gonna be putting it into our bylaws, it goes to the disciplinary. It goes to disciplinary, which will be the governance committee. Okay?
Okay.
Thank you, duly noted, Anthony. Thank you.
All right, thank you.
Okay, section 6, any member who appears to be a governmental body otherwise make public statement that conflict. Okay, we just did that. Section 7, members are encouraged to consult the board's governance, bylaws, discipline committee whenever they are uncertain as to whether conflict of interest exists. Such consultation shall be confidential and advisory. Section 8, all members are subject to Chapter 68 of the New York City Charter, conflicts of interest law, and any applicable guidance issued by the New York City Conflicts of Interest Board. Okay, that's self-explanatory. Thank you. That was wonderful. Okay, now moving along, okay, so now we're
Leave of absence.
13, yep, leave of absence. Thank you, everyone. Section 1, an appointed member who is unable to attend meetings for a period of time due to illness, disability, family caregiving responsibilities, professional obligation, or other substantial reason may request a leave of absence by submitting a written request to the chairperson of the board. Such request shall state the anticipated duration of the leave and the general basis thereof. Therefore, rather. Section 2, the chairperson of the board may approve a leave of absence for a period not to exceed 3 consecutive months. A leave of absence for a period in excess of 3 months shall require the approval of the executive committee. No leave of absence shall be approved for a period in excess of 6 consecutive months. I don't like that one. Me neither, because some people have a ongoing illness. That could be cancer, surgery. It can be a lot of things, and I don't think we should be determining that the amount of leave this person's allowed without knowing what medical conditions or anything thereof. It could be anything.
Family laws.
Right. And, you know, that just doesn't make sense. I don't think that's
Well,
for us.
the reason why I put that in there is I started to think about, like, okay, someone is taking a spot on the community board and they're not participating with the community board, even if it's a health reason through no control of their own. It's only 2-year terms. So if you're not there for a year, or if you're not there for a year and a half, are you really there? And should somebody else be appointed so that we're getting representation? So that was, I understand exactly, but that was the reason why I was thinking 6 months, but we can cut it. It doesn't matter to me, but that was the
But,
thinking.
okay, you said it yourself, it's a 2-year term. You were specific on the 6 months. We can take that out. Okay, cool. All right, moving along. Okay, go ahead, Clinton.
My issue with this is we need to be aligned in the BP's office. This is not, I don't think, a decision that we can make, because they monitor the attendance as well. And they should have say or no about this. I think this needs to go with them somehow.
Okay, so table it and Clinton's on it and we'll figure out how to proceed, okay?
Can I ask a quick question?
Yes, Ariel.
Is it generally, like, let's say there's a lot of absences from somebody, don't we already communicate like kind of like with like, let's say the president's office or whatever about that, and then they decide?
Here's the thing.
I couldn't have any type of enforcement in general when it comes to absences and when it comes to like, whatever it is. And I think that for people, it's very hard if we, have not enforced anything, have not done anything, and people show up for, in and out. Like people are, they're just not gonna understand like what that is. But go ahead, sorry, Bobby.
No. What I was going to say is the driving force behind a lot of these changes were how can we improve quorum? And one of the reasons why I wanted to put this provision in was that if we have a member that I haven't seen for a year, let's say, if that person were shelved to the point that they were on a leave of absence, they wouldn't count towards the quorum. It wouldn't count against this because for all intents and purposes, that person isn't a part of the board while that extensive medical emergency is going on. So I want us to be able to do business and meet and have quorums. So that's why I'm saying let's have a process for a leave of absence.
So why don't you just put in shall not affect quorum, shall not be included in quorum once they are allowed to have this this extended time leave of absence,
That's what I think it says.
that they will not count towards quorum.
It's section 3. That's what it
Section
says.
3,
That's what
okay.
it says.
And I read it. Thank you.
Yeah.
Thank you. So then leave it alone.
Okay. I think
We don't need the 6 months then. Okay?
I'll take that part out.
Yeah.
Okay.
All right, cool. All right, so we good. It sets to what you wanted to improve.
It's still tabled.
No, of
still
course,
tabled.
it is still tabled. Yes, my apologies. It's a long night. All right, everyone. Let's move forward. And then we on which one? All right, section 3. During the approved leave of absence, A, the members' absences from board meetings, committee meetings, and public hearings shall not be counted for purposes of any attendance tracking, non-attendance determination, or removal proceedings under Article 3 of these bylaws. B, the member of approved leave shall not be counted toward the quorum requirement for any meeting of the full board or any committee of the board during the period. I think it's safe to say that we have to table this section until he comes back from the Bronx Borough President's office with an official. All right, we're going to go straight to Article 9, District Manager and Staff. That's a biggie. So we're going to take our time with this one. Section 1, the board shall appoint the district manager pursuant to the provisions of the charter. The district manager shall serve at the pledge of the board and shall be in charge of the operation of board office, shall be responsible processing service complaint, shall preside over meetings of the district service cabinet, and shall perform such other functions as are mandated by the charter as may be assigned to district manager by the chairperson and/or board. All matters of policy shall be subject to the action of the community board. Section 2, a district manager shall be appointed by the board from candidates presented by a search committee consisting of not less than 5, no more than 7 appointed members appointed by the chairperson. The search committee shall, to the extent possible, present at least 3 candidates for the position of district manager. For consideration by the board, the search committee and the board shall comply with the rules and procedures of the New York City Department of Citywide Administrative Services in conducting the outreach and selection of a district manager. Public notice of the availability of the position of district manager shall be made in the local news media by notification of community organizations and by other appropriate means, providing sufficient opportunity for interest persons to apply. The board may reject the candidate submitted and direct the search committee to submit additional candidates. Section 3, the district manager shall be paid such compensation as shall be determined by the board or fixed by law. Section 4, the board may remove the district manager upon a written recommendation of the committee charged to hear and report specifying the reasons for such recommendation. Prior to any board action, copy of the committee's recommendation shall be served upon the district manager. The board shall consider such recommendations at a regular or special meeting held upon at least 10 days prior, written notice to all board members, the agenda of which such conflict following such disclosure, the members shall declare present but not entitled to vote. When the matter is called to a vote and shall refrain from voting, a member who is not certified to vote due to a conflict of interest may nevertheless participate in discussion of the matter. It's vague when you say committee. I'm sorry, I had to stop. It's vague. Executive, then put executive committee.
Because before, when we did the investigation last year, it was with the disciplinary committee. I think it makes more sense for it to be the executive committee personally, unless everyone disagrees with that.
I think it should be the governance committee and recommendations should be forwarded to the executive committee.
So then it's got to go to two committees.
Right.
Or you could even say basically on the line.
It should be investigated by the governance committee and then recommendations should be sent to the executive committee for evaluation.
For the middle part of section 2, I think it should still also be open.
And I also feel that it should be voted after that, recommendations from the executive. It should be voted on the community board members as a whole.
Well, that definitely has to be done.
Okay,
it says it
so,
here.
but, okay, that's probably ahead of what I'm before. But let's put clear-cut process that has to be followed.
All right, so
Okay,
you want an
and
extra.
don't be vague and say committee. Because it could be any committee.
But going back to section 2 of the same article, I don't think it should be just the chair. I think it should also be like the nominating committee that we have for our executive officers. I think we should have a committee made for the search process, because right now it's saying a district manager shall be appointed by the board from candidates presented by a search committee consisting of not less than 5 or more than 7 appointed members, appointed by the chairperson. So that's
Well,
why we think it only up to the chairperson to select the people that are going to be on the search committee for our board.
I think it should be recommended by recommendation of the chairperson and voted on of the community board as a whole. Okay, that, I think that's too much for one person. I think the chairperson should recommend the search committee should be on and then bring that recommendation to the community board as a whole to vote on. Okay, are we good on that?
The members of
All
the
right.
search committee have to be approved by the board, by the full board.
Right. But the chairperson can throw out the committee names. Right, recommendations. There we go.
Because that would literally just make it, so it's not. just
Right.
one.
Okay, what we up to now? 7? Members are encouraged to consult with the board's governance, bylaws, and discipline committee whenever they are uncertain as to whether, I did this. Why am I here? Oh, my apologies. Wow.
There's one more page, that's the almost out of section 5.
We're on section 5, you're right. Okay, thank you. I love you. The board, sorry guys, it's long night for me. Section 5, the board may employ such other staff as it may require within the budgeted appropriations for such purposes. The district manager shall hire such personnel as he or she is authorized by the executive committee to hire. The dismissal of hired personnel shall be by the district manager pursuant to the regulations of the New York City Department, citywide administrative services, applicable civil service and labor relations provisions. The board's authority over staff other than the district manager should be exercised through the district manager and not by the direct board action. I think it's his staff, and I believe it should be his decision, or hers. Section 6, annual performance evaluation of district manager. The executive committee shall conduct the annual performance evaluation of the district manager in accordance with the following procedure. A, no later than 30 days before the annual evaluation is to be present. The executive committee shall circulate a written evaluation instrument or questionnaire to all appointed members of the board soliciting their written input on district manager's performance. All responses shall be submitted to the executive committee and shall be treated as confidential. B, the executive committee shall review and synthesize all written input received from board members, prepare a written evaluation report, and present such report to the full board at a regular board meeting. The agenda for such meeting shall identify the district manager's evaluation as an item of business. C, the written evaluation report shall address at a minimum the district manager's performance of the duties set forth in section 1 of this article, responsiveness to the board and the community management of the board office and staff, and any other criteria the executive committee deems relevant. The district manager shall provide a copy of the written evaluation report and shall have the opportunity to respond in writing. Any written response from the district manager shall be appended to the evaluation report and distributed to the full board. Okay, E, the annual performance evaluation is advisory only. It does not constitute a disciplinary action, does not create any employment right or entitlement, and does not limit the board's authority to remove the district manager pursuant to section 4 of this article at any time. I agree with everything that's written there. Okay, comments from the floor? Oh, F. Thank you. F, the annual evaluation should be completed no later than April regular board meeting of each year. All right, and taking comments from the floor? No? Okay, online, any comments? Yes. Darlene first, then you.
Just a quick question. Do you all remember when we voted on that, I think Javed introduced it, that it was supposed to be like this sheet?
Yeah,
That
login.
tells us, a login sheet, tells us what happened to that.
I don't believe he began doing that. So it was made very clear.
Who was supposed to do it?
George.
Okay,
It was made very clear that that was not a responsibility of the district manager, that is what it agreed to. So that means it was supposed to take effect as of after that meeting.
right, okay.
If not that meeting itself.
It was some,
I have-
legalities that Georgia sent out.
Who did he
In
send it
terms
to?
of the,
It was pretty much discussed at nauseam though, in regards to things of confidentiality.
Yeah.
So obviously, if there's a complaint for 7, let's say, for instance, it is a domestic violence sort of situation, right? Obviously, you cannot put that. in
Right,
the
well,
complaint
that was
law.
understood.
But everything else that Javed literally expressed, which is pretty much the day-to-day operation.
Common sense.
That can go in the law and everybody agreed to have that, as long as pertinent confidential information that would be done in the case or subject to some, violation of their safety wasn't included in said law. And we all agree that said law is put on our official board website, along uploaded from meeting minutes, from committees, as well as. So who's supposed to do it?
What you want to do with it?
George.
So we need to draft it.
Before I tell you what I want to do
No,
with it.
you already have the law. You already have it already.
Sorry,
And you already voted. So it's the fact that you have. That's the main concern, because now we're in May, and now we're something that we voted on, I want to say either March or April.
all right, I'm looking at this now. Since it's added, I don't see responsible.
Madam Chair, Anthony has a question.
Okay, Anthony, go ahead.
You're on mute.
I'm so sorry. I apologize. I hit the button by mistake.
Not a problem, brother.
For the district manager's evaluation thing, do y'all mind if I share this with them, so they can see what we're looking at?
Yeah, of course. Go right ahead.
I can share that. I think that meetings that go after around 10 o'clock should have refreshments and should have food from our petty cash and shouldn't be held on us at the end of the year.
Yes, I agree entirely.
Yes, we are done. I'm waiting to take a motion to close our meeting.
So when is it
Wait,
being,
oh, that's what I'm saying.
when is it being,
She's showing it. Right?
no, when is it being handed out?
It has to
Well,
be
we
voted
gotta
on.
discuss the actual questions, make sure everybody's good, then we can get that.
So we voting on it this meeting?
We can't vote.
Well, no,
We can't vote.
Right now.
You vote, the executive committee. Right.
We're gonna bring it to the,
Right.
everyone's gonna already have it before.
On
we get to the
recommendation of the
table.
executive committee.
Right. So we're asking right now, for the questions that you guys see here, can everybody see these questions, even if I zoom in, can y'all see them?
Yes.
Okay, cool. All right, so the first one out the gate is literally saying knowledge of the district manager's duties as the district manager. Does he or she exhibit full understanding, parameters and duties of their role as indicated in the job description for community board district managers, cityjobs.nyc.gov. The ranking is simple. You're literally ranking from best to least, so disappointing all the way to exception. Oh, I have a, don't have a thing. The first one, does he or she just like you say, you say, yeah, and I literally have that. Yeah, that count. All right, so just making it neutral. Sweet. All right, second one. How would you make the district manager create understanding of Robert's rules? All right, anybody have anything to speak, or we're good with that?
I do,
That's good.
because the people that are filling this out need to know what the problem is.
That's fair.
I have a problem.
Yeah, that's fair.
And the people that also fill this out need to know what this actually job description is and why we don't.
So that's just the first question.
So we need,
This job description needs to be known to the board.
Right, so in the very first question,
Board member cannot fill this out
Right.
without knowing his job description.
so in the very first question, it literally is asking based off of his job description as seen online. Now, what we can also do for the board is attach the job description along with this question.
Yeah.
So they can actually read it. Yeah.
Want to state Robert's rules to administrative policy?
Yes.
You're gonna have to attach Robert's rules of order as well.
Well, no, just get rid of
No, we're gonna get rid of that.
Robert's rules, we said it's not a problem. If it says Robert's rules of order, you're going to have to attach that to it as well.
That's why Bobby is suggesting.
To take it out.
take it out.
I'm saying,
No, he's gonna take it
I'm
out.
saying the original form that I'm reading. That's what-
No, he just said take it out.
Yeah, we're literally tweaking it. We're working on it the same way that we just put out the bylaws.
Next.
All right, so 3, respect. At what level would you rate the district manager's respect for board members?
I think it should be asked.
Yeah, I think that's, okay, it's too precise and it seems like you're targeting a situation. I'm gonna be honest. Okay.
Loaded.
Right, no, it should be as respect to community board members as a whole. As respect to the whole community board, or individual members, not just someone with tenure. And it just seems
Well, very.
leading, I don't know.
Yeah, we're very intentional.
I-
That this came on the board as
I apologize.
someone that's been on the board for 52 years. So that's why it's encompassing of all board members. That's why it's very intentional. Because if you can treat the people that have been here very.
How about, does
People that just got this back.
does the district manager act respectful towards board members varying tenure?
That's a good question.
Yeah.
Well, I revised, I think a little bit more active voice.
Right, okay, awesome.
What could we get next time?
Yeah.
Okay. Now, 4, putting boards, all right, number 4, teamwork. How well would you rate your district manager's ability to work with others?
I would say collaborate, or maybe I'm not picking on words. I'm just trying to think of it in a way where it's more.
It's simplified, just leave it the way it is.
Yeah, I like it.
It's simplified, yeah.
Number 13, how would you rate the district manager's ability to keep track of community complaints, license requests, capital projects, and bills?
That's fine.
Anybody have any? Weapons.
No, I think it's a fair question.
Yeah, that's fine. That's pertaining to your.
Okay, number 6, comprehension. How well does the district manager comprehend state legislation, the e-learn and e-learn process, and DOT/DOE/VTAC regulations? All right, any questions, comments, concerns? You good with that one as well?
Good with that one. 7.
7, accountability. Does the district manager hold themselves accountable for personal mistakes or errors made in day-to-day tasks or interdepartmental relationships?
I don't like that one. I said, I would think we should do something that's expertise accessible to board members. What do you rate as accessibility?
Well, that comes in a later question. So this
Yeah.
one is accountability, meaning like ethics, integrity.
Okay,
Does he like course correct himself? Like when he knows that something is wrong, how does he actually respond?
Are you asking like how does he respond to it?
Constructive
Constructive criticism.
Yeah.
What was you?
So we can work with that. So instead of interdepartmental relationships, we just take that out. So we're pivot. How well does he pivot? If necessary.
okay, yeah, I like question 9.
All right.
It's a good question.
All right, we gotta see. So community board management, how well does the district manager maintain and update the community board website pertaining to the uploading of board minutes, pertinent meeting information, and roles of membership? Everybody got all of that?
Yeah, that's important.
Okay. And
Yes.
9, interagency relationships. So this is what kind of our answer the question before the last one. How would you rate the district manager's working relationship between city agencies, board members, and BxCB12 staff as it pertains to transparency and achieving mutual objectives?
I like that one. 10.
Right? 10, community engagement. How would you rate the frequency of which the district manager attends events within the community conducted by the community stakeholders?
Yeah, that's.
Okay.
11, professionalism. Does the district manager conduct themselves in a manner that is appropriate of their station when communicating with community stakeholders, elected officials, and community board?
I think that's a fair question.
And last but not least, facility management. How well does the district manager maintain equipment, public meeting spaces, record, BxCB12 event inventory, and video / audio equipment?
That's a good question.
Good question.
All right.
Typically, I understand disappointing is one, right? Exceptional is 5.
Yes.
I don't really like the word this. The other word being
Unsatisfactory.
Right. Yeah. It like something you say to a child. Right. I don't like it either. All right. Unsatisfactory.
Unsatisfactory.
All right. So in between the question, there's a justification of score. So that gives people space to explain why they scored where they did, and also gives your feedback why they did. All right, the bottom of the page, literally just giving a space for people's titles that they have on the board, as well as the city, well, the name and the signature line and the date of the mission. So the main thing is that if it's in their hands in the May meeting, they give it back to us in our hands in June, whether it be via email or actual hard copy.
You're not gonna get it back.
Why?
I think they're not gonna remember to bring it with them.
I'll call everybody.
Yeah, I feel like the only way you will get it back is if you just do it the same day.
Right. I think
Same way I call about meetings.
no. Ariel has a legit statement right now. I believe it should be filled out during the meeting. At some point, it should be given in the beginning of the meeting. By the end of the meeting, it should be collected.
Only because like I'm thinking about like when I'm in church and everything and they're giving out things, it's like because it's a month and people, life circumstances, in order to make sure like that's the biggest time that we get everybody, you're gonna get all the papers that day.
Glenn, do you have any objections of us
Say
being a part of the agenda for May?
Unless you guys
You have conflict?
Not at all.
unless you guys want them to hold on to it, so they can think more and be able to
Yeah,
fill
that's
out.
kind of quick.
All right, Ursula, what you have to say, Ursula?
Yeah.
Everybody online, y'all have anything to say?
I don't think we can use the mic.
They say good night. I'd like to. They said-
Okay, can we have a motion to end this committee, governance committee meeting?
I like to say something. I like to
We
say
have a
something.
sec-
Hello?
second.
I like to say
Yes,
something.
yes, Anthony?
I like to say great job, Denise and her team. You did a great job for the first meeting.
Everyone here, we, collective. All right, can we have a second?
Close.
Second? Okay, meeting's over. Thank you, everyone. I gotta go to the bathroom and then I'm out of here. Yes, it was. I agree. Everyone.
So what is, so what, look at that. So what is,
Thank
so
you.
what is, I love,